The attorneys general in Tennessee and Virginia have sued the NCAA, and the question is, are there more states coming? In a lawsuit filed Wednesday morning in federal court in Knoxville, the Tennessee and Virginia AGs accuse the NCAA of violating federal antitrust law based on recent enforcement of NIL rules. And basically, what's going on is the NCAA is looking into cases involving NIL, where basically they are accusing schools of using NIL to induce recruits or discussing NIL payments with recruits. And it's not even the schools necessarily being accused, it's the collectives attached to the schools that are being accused of this. And we know Tennessee is being investigated. We know Florida is being investigated. There are other schools under investigation right now. We're not entirely sure who those schools are, but I imagine we're going to find out here in the next days and weeks. So basically what this lawsuit is asking is a judge to issue either a temporary restraining order or an injunction that says, hey, these rules don't apply because they violate the Sherman Act. And do they? Well, the way to check on this is it a bunch of competitors colluding to keep a certain group of people from making as much money as they can? Well, yeah, the answer is yes. It's the schools made these rules through the NCAA to keep their costs down. So there's a really good chance that a judge is going to rule that this does violate antitrust law. And the NCAA will have to come up with some sort of, they call it pro-competitive justification. And we've seen in past NCAA antitrust cases, they don't really have any good arguments. Their best argument in the past was people like it better when the athletes don't make any money, which isn't based in fact. And in fact, since NIL payments came into existence, college football ratings are up. In fact, ratings are up across the board. Sports are more popular now than they've ever been. But the NCAA has to come up with a way to claim that this is a pro-competitive thing. So they could say, well, these rules exist to make it more fair, to make it more equitable. In the sport of football, that's going to be hard to argue because when the rules were really in effect and as strict as they could be, college football was probably the most competitively unbalanced sport of all the major sports in America. And in fact, has become more balanced since the NIL stuff came into effect. So this specifically deals with recruits. And what makes this feel so big is that this is kind of the last piece of it. Because yes, you can pay current athletes. You can discuss NIL deals with current athletes if you're the collective. To say you can't discuss it with a prospective athlete is just silly because, one, those conversations went on under the table long before NIL was allowed. Two, those conversations go on now. You cannot sign a good football player or a good basketball player right now unless that person knows what their NIL situation is going to be coming to your school, whether they're coming out of high school or whether they're coming out through the transfer portal. It's just a piece of information that they require before they make that decision. And what the attorney generals are saying is you can't keep that information away from those players because you are trying to suppress that market. So what happens if the TRO gets granted? What happens if an injunction gets granted? Well, then the collectives can just talk to recruits about how much money they're going to make, which, spoiler alert, they already are. All this would do is make it where the system that has come into place since NIL became allowed in 2021 would not be against NCAA rules. And the reason this is such a strange situation, I don't understand why the NCAA went after schools on this. All the schools are doing it now. So it's not like they're going to say, oh, you got Tennessee, you got Florida State, you're getting Florida, we're fine. No, they've got the same things going on with their collective. So if they can get Tennessee, if they can get Florida State, if they can get Florida, they can get you too. And I don't think the schools are going to put up with that. Remember, the schools are the members of the NCAA. Now, a lot of the complaints about this situation is they have not been able to shape the NIL rules the way they would have liked, the way the normal process would allow. Part of it was because that normal process is extremely bureaucratic. It takes a long time, and they've been trying to hit a moving target with all this NIL stuff because it's a rapidly evolving thing. But the NCAA going after some of its biggest schools and saying, we're going to enforce rules that weren't necessarily in effect, or we weren't sure were in effect when this stuff happened, that was a bad idea, because that's what brought this case into court. And that is probably going to get that rule kicked by the court. And if it is, I don't think it's ever coming back. See, just like the stuff with NIL, when the world didn't end, when players started getting paid, and in fact, the game got a lot more interesting because, shockingly, unless you listen to the economists, players started moving to schools where they wouldn't have necessarily gone before, and it made it where more schools could actually compete for the national title in football. So this is going to be a fascinating case because this is one of the most direct attacks on the NCAA, just saying, hey, your rules are not sacred. We're going to let this happen, and the world is changing. It's still up to the court to decide whether that happens or not. But given recent history, it probably will. We saw it with the transfer rules last month. 7 different state attorney generals jumped in on that case, which started in West Virginia, and the transfer rules had no chance, basically. TRO was issued, then an injunction was issued, and the NCAA just sort of backed off because they understand once it's declared illegal, you've got to figure out something else. And so the schools ultimately need to go back to the drawing board, figure out something else. Perhaps that's revenue sharing with athletes. Perhaps that's viewing athletes as employees and bargaining collectively with them, because if you do that, then you can't challenge the rules on antitrust grounds. Like if they want to make transfer rules, or they want to make a salary cap, compensation rules of any kind, they got to collectively bargain those. Otherwise, they're going to face the same challenges they're facing now. And what they're realizing is the schools aren't necessarily their friends. The states aren't their friends. They don't have a whole lot of friends left. But that is the NCAA. And they haven't made a lot of good decisions through this entire process. But going after some of their biggest schools for stuff that everybody was doing is probably going to be their biggest mistake yet. Thank you so much for watching. Just a reminder, subscribe to this channel right here so you never miss an episode of Andy Staples on 3. And oh, by the way, watch all the other great videos on the On3 Sports YouTube channel.